forum sponsored by the Barbara and Norman Tanner Center for Nonviolent Human Rights Advocacy. And for those of you from out of town, we have to go through that entire spiel because there's a second Tanner Center on campus that has been around considerably longer, that is actually supported by and founded by a different family, but they're related. But this is Barbara and Norman Tanner Center, who've just been magnificent influences on the community and on the university, and are lifetime devotees committed to alternatives to violence in Utah and in the world. And we're just very pleased. And we welcome our out-of-town guests as well as our distinguished in-town guests. I think you know, again, this is the second annual conference sponsored by, or forum sponsored by this center. Last year was our kickoff in which we focused on issues of nonviolent alternatives to terrorism. That has led to a coalescing of faculty across this campus that has been exciting, and the benefits of what we've been doing go far beyond simply the couple of days that are here. And I understand from our editor-in-chief of the edited volume, and I'm looking also at the series editor, that we are very close, again, still, to having an edited book from last year's conference. Again, last year we were very, very pleased to have Amartya Sen, Martha Nussbaum, Bruce Hoffman, and others come in and speak to us. But again, how many chapters, roughly, papers? Approximately. About 14 major papers. And that hopefully will be off the press very soon. And we expect equally dramatic results from the conference today. I will turn the program over now to Professor George Chaney, Department of Communication and Director of the Barbara Norman Tanner Center.
Thank you all. As is the case with most conferences, we're already running a little bit late, so I'll abbreviate my comments a little bit, but I do want to offer some thanks initially and chart out some of the things that we'll be doing today. Very briefly, our center includes not just an annual academic conference of which you're taking part, but also the Peace and Conflict Studies undergraduate minor, outreach to K through 12, a summer youth summit and teacher workshops, a peace library, campus community dialogues, and a new project called the Utah Council of Elders. Over the last 10 years, I've had the great privilege of visiting a university in New Zealand on a regular basis. And at conferences in New Zealand, there's a wonderful tradition that is to pause and reflect on place and people. And this is inspired in part by the bicultural constitution of the nation of New Zealand. But I was really inspired by that in academic events that I've attended there, because I think for many of us who are so privileged to not only be interconnected virtually, but also to be able to jet around the world for discussions like this, it's good to be reminded of our own embodiment of the places that we occupy, and in this case, to recognize all the peoples who have passed through this part of the United States, the Salt Lake Valley, and what is now the state of Utah, and people who are here now. So I just wanted to pause and reflect on that. Let me thank very briefly our co-sponsors. You have a list of those in the program, the thin brochure that you have. But these include SHMAD, Perspectives on Prejudice, a community organization, the College of Humanities, the S.J. Quinney College of Law, College of Social Work, Departments of Communication, Economics, Philosophy, Political Science, Psychology, the First Unitarian Church, the Honors College of the University of Utah, the Institute for Public and International Affairs, the Middle East Center, the Office of the Associate Vice President for Diversity, the Office of International Programs, and the Office of Undergraduate Studies. So this has been an incredible group effort putting together what we think is a very, very timely and rich series of discussions. I also want to give thanks to people who are not listed in the program that you have, without whom this would not be possible. And I especially want to highlight Alita Tu, Program Manager for the College of Social and Behavioral Sciences, Victoria Medina, Executive Secretary in the same college, Sarah Moyer, and Rick Pike, but also the rest of the staff who are pitching in these days. So you'll be seeing them throughout the conference, and let's give them a big hand. Many of you who are visiting already know them well, at least virtually, and so now you'll get a chance to meet face to face. Steve mentioned last year's topic and all of the products of that discussion about terrorism, values, and violence. And let me preview very briefly, or at least mention, next year's conference topic, which will be human aggression, evolutionary processes, and cultural contexts. And that is already being put together by a team of faculty who represent 3 different colleges, including Elizabeth Cashton, who's the chair of the anthropology department here at the university. So we're really looking forward to that conference, which will include a number of prominent scientists from the United States and other countries. Our topic, migration, rights, and identities, in a sense deals with the oldest form of globalization. And we are very pleased to be talking about a whole range of issues under that heading, from concepts, definitions, and categories, which is the subject of the first panel today, to comparative cases around the world, to questions of local policy, which we'll be talking about at the end of the day tomorrow. And we're very pleased tomorrow afternoon to welcome community leaders who are dealing in a very deep and specific way with issues of human migration. You have the program for the day in front of you. I don't think there's any reason for me to reiterate that, but you can see the progression of panels from concepts and definitions to causes and patterns to the effects and experiences related to immigration. So with that, I would like to turn the floor over to Erika George, professor of law here at the University of Utah and an expert on human rights. And she will moderate the first panel and introduce our first group of scholars. Erika?
Thank you. I'd like to invite my panelists to please come forward. Yes. So our panel will be talking about concepts, categories, and definitions. Migration is considered one of the defining issues globally of the early 21st century. And as more and more people are on the move today, more than at any other point in history, it's really an important time for us to reflect. There are more than 192 million migrants or people living outside their place of origin at this time. That means that roughly 35 persons in the world is a migrant. That's about 3% of the world's entire population. So people are moving from states that are sending states to receiving states. It's not an issue that, there's no state that's not affected by this issue, in other words. And discourse on migration, therefore, needs to involve many perspectives. And we have multiple perspectives today to help us think through some of the many issues that are presented by receiving migrants, by having your population leave in numbers. So in order to do that, I think it's important to think through how we might pose questions, how policymakers and practitioners can better be informed in making decisions about how we address and meet the stranger in many instances. So we'll be proceeding from our most specific speaker, who will be talking about issues here in Utah, to the most broad, which will be Professor Chatterjee. First, we have Professor Ken Jameson and Professor Julie Stewart. Professor Jameson's from economics. Professor Stewart is new with us here, I guess, in sociology, and her research focuses on issues of development, social movement theory, and concepts such as collective identity. Following Professor Stewart and Professor Jameson will be Professor Wayne McCormack, my colleague in the law school, who's widely published on many areas in constitutional law and increasingly international law and the law of terrorism, and he'll be speaking about some of the origins of how the law thinks about migration. Following him will be Professor Anghie, also my colleague in the law school, whose most recent publication is a book from Cambridge University Press on imperialism, and he'll be speaking further about tying the history of international law of migration to the present contours of it today. And Deen Chatterjee, I've recently learned that Deen's full name is from the Sanskrit Dipan, is that correct? Dika? Yes. Which means the giver of light. Is this true? And he will be offering us some light and insight on the whole of this topic. So with that, I turn to Professors Jameson and Stewart.
Well, we hope you won't have to wait until Deen to get some light on the topic. We'll see what we can do here. Those of you who are in Utah realize that we've been about close to 2 months now with our legislature, and the major issues have been immigration issues. And it will be very nice to end up our session beginning to talk about principles and rights and norms and institutions and how they should affect immigrants. That is not much of the rhetoric which actually occurs in the legislature. So we want to look at exactly one of the most important laws that has to do with rights and identities of migrants, and deal with why that law came about and how the whole debate about that has evolved, so we can understand that process.
Okay. All right. So we're going to focus specifically on basically the whole trajectory of how driver's license have been extended to undocumented residents in Utah, and basically then the backlash that occurred and the current trajectory of, or the current status of this policy that is actually just being debated, as Ken said, in the legislature. And so this issue of how and why certain rights are extended to undocumented residents is of course important to us because we've been living in Utah and experiencing this debate over the last 10 years. But indeed, this is a debate that is also happening in other parts of the country, and we want to kind of contextualize it at first to give you a sense of how the debate that's happening here is actually much more broadly applicable outside of the borders of our small state. So one of the places where this issue has been debated very vigorously is in New York State. So just last year, in the fall of last year, Governor Eliot Spitzer basically signed an executive order to allow people with valid foreign passports to obtain a New York driver's license, even if they didn't have a valid Social Security number. And what he said in justification of this proposed legislation was that as long as I'm a governor, we will not pretend that the undocumented do not exist. We will not cut them off from participating in our society, and we will not become part of a myth that is propagated at the federal level that they are not here. So this was an important recognition that there are people that are contributing vast amounts to the economy and the society of the state of New York that needed to have some kind of formal recognition. Sadly for New York State, he later had to withdraw this legislation because of the immense controversy it generated. And we saw some insight into the kind of controversy around extending driver's license to undocumented migrants on the national level during the one of the debates, the Democratic presidential debates, the one that happened in Philadelphia in October of last year. So basically a question came up and it said, would you support driver's license to undocumented residents? And 5 of the 7 nominees, Democratic candidates at the time, said yes, we would. But then, of course, as the media tends to do, it honed in on Hillary Clinton. They asked specifically, okay, Hillary, they put her on the spot and said, given that she's a senator from New York and there was all this controversy about the driver's license initiative in New York. And so she responded, she said, well, I understand the sense of real desperation trying to get a handle on this. She said, remember, in New York, we want to know who's in New York. We want people to come out of the shadows, and Spitzer's making an honest effort to do it. But then she was pressed a little later by Tim Russert, and he said, all right, are you going to go up or down on it, Hillary, up or down? And she said, well, you know, I don't know. I just want to add, I did not say that it should be done, but I certainly recognize what Governor Spitzer is trying to do. So this kind of captures the controversy and the conflict about how do we deal with undocumented residents in our state, in our country. And something that is now really of national concern basically started out here in Utah. Well, not started, but Utah was one of the first states in the country to really try and get a handle on this. So what we are going to do now is briefly go back into the history of HB 36, which initially granted driver's licenses to undocumented residents to see the policy trajectory, to kind of get a handle on what happened here as a way of understanding what's happening now on the national level. So in 1999, Utah Governor Michael Leavitt signed the law, HB 36, driver identification law, into law. And basically this said if you're an undocumented resident, you can obtain a driver's license. And basically the one thing we want to underscore about this piece of legislation is it not only gave migrants or undocumented residents the ability to drive legally, it also allowed them to get car insurance. It served as a form of legal identification so that people could open bank accounts, and it even allowed people to get credit cards, and it opened up people to a whole range of consumer activities. So it was a really important step in moving people into documentation and legalization. However, in the ensuing years, there was a lot of controversy, a lot of criticism, and so when it looked like the entire legislation would have to be repealed in 2005, 2 years ago, basically it was replaced with a driver's privilege card, which is basically a pared-down piece of legislation that allows undocumented residents to get car insurance, but to do nothing else. It was no longer issued as a state form of identification.
So I think it's important to get some sort of a sense as to who we're talking about, and the fact that we're talking about a large number of persons who reside here in Utah. And a number of us are working on some research projects that allow us to isolate that. And you can see that according to the statistics, by 2007, there were, I can't read it off my notes, 94,453 people who had gotten either the driver's license or a driver privilege card. And we can do that year by year, except for the ID cards. Some people don't drive, but they get them for ID cards, which have no date on them. So we're talking about a significant number of people who were brought in some degree into the system by these policies. Now, who are the undocumented? You can see that, as we would expect, they tend to be very heavily male. They tend to be much larger than the overall population. They tend to be much younger. They're working age, and that's really, in many ways, how they've contributed to the economy of Utah. They tend to be, the data suggests, and this is a bit misleading, that perhaps their health is not quite as good as the immigrant health paradox would say. But they're very heavily, in terms of the undocumented, they're very heavily from Mexico. Now, about 42% of the foreign-born population is from Mexico, but around 84%. So these are the people that really have been the target for the 13 pieces of legislation that have been in the legislature and are now shaking out right as we speak. So these are human beings, again, and their situation was greatly affected by this program.
Okay, so now we want to move from empirical questions to theoretical questions really briefly. And I know we have a little less time than anticipated, so I'm going to skip right to the social learning approach. And basically, we wanted to look at this, at the policy trajectory of HB 36 and understand it from some kind of theoretical perspective. And what we chose to use is an ideational analysis, which basically looks at ideas in policy. It basically tries to figure out how and why are certain ideas and concepts appealing to policymakers, and how does that shape how they initiate different kinds of policies. So just for a couple of minutes, we'll focus on social learning, which is basically most closely associated with Peter Hall. And he built upon Hugh Heclow's, He built upon Hugh Heclow's kind of famous concept that politicians not only power in politics, they puzzle. And so social learning is basically this idea that policymakers engage in different ways of trying to figure out ways to pass policy that is going to effectively solve the puzzles that face them at any given time. And typically they work within the context of a paradigm, which is basically a set of ideas and measures that adhere to a particular kind of worldview that shapes one's actions and one's understanding. So if you look at the social learning approach, within a given paradigm, basically there's 6 stages that describe how policy evolves, and indeed we've already seen that HB 36 underwent quite a dramatic evolution. Reigning orthodoxy is the first stage. That's basically when the status quo is right there. Accumulation of anomalies basically says when certain aspects of an environment start to question that paradigm and that can't kind of fit into the paradigm, then we see the anomaly stage. So then typically policymakers start to experiment. They try and figure out, well, how can we adjust the policy to meet these new challenges in our political and social environment? If they're unsuccessful, we see a fragmentation of authority. New policymakers emerge that try and take over the stage and basically and work on the policy and try and come up with something new. And then we see contestation when new actors come into the realm of policy and engage with these new authorities. And then we see a new paradigm emerge. Okay, let's see. All right, so
the way the law actually happened in Utah was with a whimper, despite all the controversy today and this last week. It was introduced, and there was almost no opposition to the law to provide driver licenses to people without Social Security cards. As Ure said, this sounds like Elliot Spitzer. Well, they're here illegally. Why? He was prepared for the onslaught, but really got very little of it. He expected people to say that they're here illegally, and why should we help them? But no one did at that point. And a lot of that had to do, I think, with Utah being a new destination without much experience with migrants. And so people were really not aware of the role of migrants into Utah. But probably most important for at least our understanding of it was the fact that it was introduced without any kind of a causal story, without any kind of a paradigm, which I think accounts for much of the difficulty that we have. We're going to deal with this year after year after year, and the reason for that is because there wasn't really a causal story or a paradigm. So what's happened since the law was introduced in 1999? A number of anomalies consistent with the theoretical structure have appeared. The earliest one was that states like Arizona, who have a lawful presence law, would not accept Utah driver's licenses, and this came back to redound. Secondly, much of the support had come from people like law officers and others who believed that it was functional, and health people who believed that it was quite functional, and now that coalition began to fragment. Oops, sorry.
Okay. Oh, we did that one. Sorry.
Yeah, we did. Okay. Sorry.
Okay.
There we go.
All right. So basically with the, I'm sorry, we skipped through those. So basically with the accumulation of these anomalies and the fragmentation of authority around HB 36, basically then we started to see a lot more public outcry, a lot more discussion about what was happening, what were the impacts of this policy. And so this is the stage of contestation. So at this point, large numbers of the undocumented came out of the shadows, and they were willing to risk the light in return for an identity document. And as Ken mentioned, supporters basically of the law could point to all of the many benefits that had accrued in the time that the driver's license initiative had been in place. As we'll talk about in the conclusion, there was a very large increase in the number of undocumented residents who had car insurance, and so the public safety aspect of that was very well documented. But basically, those kinds of questions kind of were shunted to the side, and opposition grew, and by 2005, as we've mentioned, basically it seemed very clear that there was enough opposition to vote HB 36 out of the law. And so basically then we met the experimentation phase. And one thing we would highlight here is that Hall has this very neat sequence of how policy emerges. And as you may have noticed, although you may have not captured entirely your attention, we have all the same phases in looking at HB 36 and its trajectory, but they skip all around. So basically, he basically, I think, correctly identifies all the kinds of stages one might expect, but in this case, it didn't follow like a linear kind of model. It kind of jumped from one stage to another. So now we're back to the experimentation phase, which he said would have happened earlier. And so what happened in the experimentation phase is basically the legislature changed the law, and it said if you have a tax ID number, you can now obtain a driver's privilege card. And basically it's not valid for as a state form of identification, but it allows you to drive legally and get car insurance. But basically there was a lot of inconsistency about who would accept it from the private sector, and so there was a lot of confusion about it. It brought about a lot more kind of nuanced ways of issuing it and regulating it. So, for example, once someone got a driver's privilege card, it would expire on their birthday following July 2005, and then they had to renew it every year. And the law also increased the amount of documentation that someone would need to provide in order to get a DPC, such as proof of Utah residence. So here we just see kind of like a watering down of this policy, and a kind of it became much more complex rather than a very straightforward policy.
So we'll let you read the conclusions, but three things. The program's been quite successful. Secondly, it will continue to be controversial every year. And a lot of the reason for that relates very directly to the speakers who will come after we do, that there really is no agreed upon causal story, no agreed upon paradigm, no agreed upon set of rights, no agreed upon set of institutions or norms that really dominate here. And until, in some sense, the influence of Tony and Deen can bring those dimensions into the legislative debates within Utah, we will continue to debate what is actually a quite successful program. Thank you.
Due to the time constraints, what we've agreed is that each speaker will present, and then we'll open for questions to the entire panel at the conclusion. Yes. Either way.
Good morning. My name is Wayne McCormack. As Erika said, I'm from the law school. And about a year ago, when George asked me to put together a paper on the law related to migration and immigration, I said, but I don't know anything about it. And he said, what a perfect opportunity to learn, right? So in the true spirit, here's my senior thesis for you. I actually started back with my early childhood memories of migration stories, which came from the book of Genesis. And amazing stories. I mean, you start with people selling their wives into bondage, trading relatives for cattle and livestock, migration, incest, and there's just all this wonderful glorification of violent conquest of other people's territory. So, you know, it sets a pattern, I guess. But the thing we have to realize about those stories is they arise long before there was any concept of national borders. And as Tony will elaborate, I think, a little further, this idea of the nation state really starts from about the 17th century and is part of the story of colonialism, imperialism, because the nation states of Europe were figuring out how to protect their own borders while also then dealing with each other as they clashed around the world in pursuit of other territory. So what we have is a legal regime based on national boundaries, which then encompasses at least three different layers of law for us in the U.S., and sometimes four. There's international law, the law among nations. There's national law, domestic law, the law of the nation state itself. In our situation in the U.S., then we have state law, as Ken and Julie were just describing. Many of the controversies in which we're most heavily interested are clashes between state and federal or clashes among states. And as I say, we can even have a fourth layer in this country because some cities will get into the act. Cities and counties may have their own rules that they want to promote. So my task here really is just informational, just lay out as quickly as I can what the sort of relative content of these different legal regimes might be. So the international law that applied, or as applied, in the European conquest of the Americas is interesting. And I'll just briefly quote from Chief Justice John Marshall trying to explain how it came about that this conquest could occur more or less legally. I think I have to say John Marshall probably had his tongue fairly firmly in cheek with this passage. On the discovery of this immense continent, the great nations of Europe were eager to appropriate to themselves so much of it as they could respectively acquire. Its vast extent offered an ample field to the ambition and enterprise of all, and the character and religion of its inhabitants afforded an apology for considering them as a people over whom the superior genius of Europe might claim an ascendancy. The potentates of the Old World found no difficulty in convincing themselves that they made ample compensation to the inhabitants of the New by bestowing on them civilization and Christianity in exchange for unlimited independence. The point of this passage really is Marshall wrote a whole long opinion about what's the theory, the legal theory by which one nation could conquer another and colonize it. And basically the theory was we can do it because we can do it. International law at that point said that if you prevail in conquering another, you claim the territory, and then it becomes yours. It really was an expression of might makes right. But don't violate the borders of another civilized nation. And that's what Tony will, I think, probably describe a little more thoroughly. So there was this difference between civilized and uncivilized. Fast forward to today, and we have still retained now the one overarching principle of international law, which is respect for nation borders. National borders are sacrosanct in the theory. Another principle that is almost equally firmly embedded, but with very little recognition and enforcement, is this notion of self-determination, that people have the right to determine their own rules, which means each nation can decide who gets to enter and leave. Right? Now, those two principles relate to the nation state. Then, since World War II, we've started promulgating many principles of individual rights that are to be recognized by these nation states. So you see an overlay on top of this sanctity of the nation state on behalf of individuals. So let me just run through a few of the principles of individual rights that have arisen in the last 50 years. And these are embedded in a variety of declarations and covenants and treaties, so I'm not going to get into the details, but I'll just quickly mention them. First, right to immigrate, with an E. That is the right to leave one's state of nationality. No person can be forced to remain in his or her own home country. Second, right of entry back into one's nation. So there is at least a strong presumption against the notion of exile. You know that both of those have been violated by many nations in recent memory. Third, which is related to both of those, is no forced relocation of peoples, forced expulsion of groups. Again, violated with ethnic cleansing in a number of localities throughout the world in recent times. The former Yugoslavia, several African nations, we've seen patterns of relocation that the international law would condemn, but there's very little in the way of an enforcement mechanism. Skip over a few other things. Very quickly, you can find them in the paper, other individual rights, but the principal rights that we can look at here are the rights to leave your own country, to migrate to somewhere else, is not greeted with a corollary of a right to entry into someone else's country. You only have the right to entry back to your own. So that's the tension under which we're operating. All right, U.S. domestic law, very quickly. The brief history, and again, this is in the paper. We started with open borders. For the first century or so of the U.S. existence, we had no rules other than some which arose in the westward expansion during Reconstruction following the Civil War. Starting in 1875, Congress banned convicts and prostitutes from entry into the U.S. 1882 expanded the list to include idiots, lunatics, and persons likely to become a public charge. This gave a little bit of discretion to the enforcement officers as to who was going to be allowed to enter, of course. The notion here is simply one of we have open borders except for we can exclude certain kinds of people that we don't want. That prevailed through the early part of the 20th century and kind of reached a crescendo, I guess, with the Chinese Exclusion Act of 1882, which excluded all unskilled laborers and Chinese employed in mining. So they wanted the Chinese to build the railroad, but then that was it. No more unskilled Chinese labor. Very clean and clear example of jingoistic approach to immigration. And there's lots of reasons behind that that I won't get into at the moment. We'll have to leave that alone. That was replaced, this whole notion of exclusion was replaced in the 1920s with a quota system, establishing quotas for the number of persons from each country or continent who would be allowed to enter as residents. And that was true through about 1990. And the 1990 Act replaced the quota system with a category system. So we started with categories that could be excluded. Then we went to quotas of locations from which people would be allowed entry. And then the third stage was a system in which there were categories of people to be accepted for entry. And right now, we have a limit, a worldwide limit on all immigration of 675,000 per year, not counting refugees. Of those 675,000, about 480,000, about two-thirds, a little over two-thirds, are family reunification measures. So the remainder are for categories who would be of interest based on employment or education. And there are priority workers who are given priority in these categories for people who demonstrate extraordinary ability in the sciences, arts, education, business, outstanding professors and researchers. Okay, so we can come and go. And an interesting one, multinational executives and managers. So let's keep business in its proper position of priority. Obviously, this strikes at the unskilled labor market, and that makes it difficult for the unskilled labor to enter, which is exactly where the economic arguments now come into play. Business wants the unskilled labor. The person in desperate straits in their home country sees a potential opportunity, comes in perhaps legally by entry as a non-immigrant, and then stays. The economic arguments then are, is that a good or bad thing? And I'll have to leave that to the ravages of time itself, because there's one thing I do want to highlight for you based on the issues that are most paramount regarding state law. And the starting point here is, so I've talked international, then I've talked national, and I'm going to talk state momentarily. The starting point is the Supremacy Clause of the U.S. Constitution, which makes federal law supreme over that of the states. With regard to immigration, which is specifically given to Congress, the Congress has the power to set rules for immigration and naturalization. If the state does something that conflicts with federal policy, then it will be superseded by federal law, preempted by federal law. The Supreme Court has left this to be a rather vague situation. In a series of cases dealing with state attempts to limit the degree to which property within the state could be inherited by people in other nations, the court has left it to sort of a case-by-case exploration as to whether that policy actually conflicts with federal policy. That's unsettling because it means you don't have clear lines as to what's valid and what's invalid for state law. A little more clear is the Supreme Court's unwillingness to accept much state legislation that affects the undocumented. Texas had a law adopted in 1975 denying to undocumented school-age children free public education. As the Supreme Court described this, it then created a distinction between the undocumented and the residents, the nationals, that was not warranted by any state or federal purpose. And I quote, "It is difficult to understand precisely what the state hopes to achieve by promoting the creation and perpetuation of a subclass of illiterates within our boundaries, surely adding to the problems and costs of unemployment, welfare, and crime. It is thus clear that whatever savings might be achieved by denying these children an education, they are wholly insubstantial in light of the costs involved to these children, the state, and the nation." And then California, despite that language, nevertheless adopted Proposition 187 in 94, which prohibited the use of state funds to provide to undocumented aliens any social services such as education, health care, and welfare. That was struck down by the lower federal courts, and the state chose not to appeal. So what I've tried to describe here is that state law is limited by federal law in two different ways. One is that the state cannot conflict with federal policy, but secondly, if the state does make distinctions with regard to undocumented aliens, those distinctions have to be rational and serve some compelling, or not compelling, some important state purpose. So I will leave it at that. Thank you.
Okay. Next we have Professor Anghie.
Thanks very much, Erika. May I begin by thanking George Cheney, Stewart, and all the other people at this university who've made a tremendous effort to make the university a much more internationalized place and to help the University of Utah really become a center for the study of international affairs and the way in which those international affairs affect this state. May I also thank the Tanner Human Rights Center and Alita and Victoria, who were very important in organizing this conference. I very much appreciate Ken's invitation to actually set out a paradigm which will resolve all the complications we are trying to deal with today. But not for the first time, it turns out the law, I'm afraid, is going to disappoint. And so all I can do in these circumstances is to try and outline the way in which the law has developed over many centuries in relation to two principal issues. The first issue is the issue that Wayne addressed, which is the issue of, is there a right under international law for the movement of peoples? In other words, is there some kind of a right to migrate? The second basic issue that I would like to address is the question of what are the rights of aliens once they have entered a foreign territory under international law. There are many other issues that could be addressed, such as the issue of citizenship. How can foreigners be assimilated into a country? Are there any international rules in relation to that issue? But for the moment, I will focus on just the first two of these problems. And in fact, somewhat reversing Ken's invitation, I would suggest that really lawyers need to look to social scientists, to political scientists, and to philosophers, really, to get some sort of an understanding of what the reality is, because a law which is completely removed from that reality is not going to be particularly successful. At the same time, of course, we do understand that the law has a normative component, and that the law should aim towards furthering what might be grandiosely called international justice. Perhaps a grandiose term, but something which I think is very important to keep in mind nevertheless. Let me begin with the first, you could say, international lawyer, at least a lawyer who is regarded in the tradition of the history of international law as being the first international lawyer. And this was a Spanish theologian. His name was Francisco Vitoria. He was a Dominican priest. And the book he wrote was a book about the rights of Spain in relation to the Indians. So what he was really focusing on was the question of how could Spain claim title to the New World? And in articulating a set of ideas about that, really, I would suggest in terms of our conference, what he was doing was articulating a set of principles which had very much to do with this whole question of migration. Because what he said was that people had an absolute right to travel and trade. So this was a very powerful right which no state could actually undermine. So in other words, he said the Spanish had an absolute right to travel and trade in the New World, and they could continue to do so unless they caused some type of harm to the natives. Equally, if the natives in any way opposed this absolute right to travel and trade, then the natives themselves would be violating international law. And if the natives violated international law, then, depending on the circumstances, it would be proper and appropriate for the Spanish to exercise their right of self-defense. And once the right of self-defense was so exercised, it could lead to a situation where it was necessary, reluctantly of course, for the Spanish to actually conquer this area and depose the sovereigns of the New World. So the right to travel and trade was very important. Equally important was a right to actually proclaim the gospel. And this was an absolute right as well. And in fact, the interesting thing about Vittoria's text is that his whole, you could say, discussion of international law begins with a quotation from Matthew 28:19. Go ye therefore and teach all nations, baptizing them in the name of the Father and of the Son and of the Holy Ghost. That is, you could say, the epigram to his whole discussion of the legal situation as between the natives and the Spanish. The other interesting thing about Vittoria's concept, and I have to say that Vittoria is a very interesting figure because he goes quite far in at least displacing the idea that the Indians are not human at all. Because one of the arguments being made at the time was the Indians are not human at all, and therefore we can simply acquire their lands because those lands don't belong to anybody else. Vittoria at least said the Indians are human. They do have rights which must be respected. So Vittoria is a very interesting and ambiguous figure. But another, you could say, major concept that in many ways underlies his whole philosophy is the concept that the whole world is something that everybody holds in common. So if I can quote his argument, he says, in the beginning of the world, when all things were held in common, everyone was allowed to visit and travel through any land he wished. This right was clearly not taken away by the division of property. It was never the intention of nations to prevent men's free mutual intercourse with one another by this division. So there's an idea of a world held in common. And this idea is also found in Kant, as Professor Ben Habib has showed in a wonderful book, The Rights of Others. This whole idea of the world being held in common and therefore everyone having a right to travel. Of course, it's not difficult to see, and this is a point that Wayne has already made, it is not difficult to see how this same set of ideas could be used for imperial purposes. And in terms of imperialism, I think what we have to focus on is not so much the concept of migration per se, but on the concept of trade. So it is through the international law relating to trade that we can get some sense of an implicit set of ideas about migration. So that is my suggestion. So when it comes to the issue of trade, once again, this was presented as an absolute right. And in the 19th century in particular, this absolute right meant that European states could actually enter into the territories of non-European states, always proclaiming the right to trade, the absolute right to trade. And if we see this right being proclaimed by international lawyers, we would note that Hugo Grotius, who is generally regarded as the father of international law, himself follows Vittoria in saying that there is an absolute right to trade, and no sovereign can actually undermine or take away this right. And of course, what is interesting about Grotius is that not only is he the father of international law, because he is seen as the great theorist of Westphalian sovereignty, which is something else that we need to discuss. But the other important thing about Grotius was that he was, in fact, the lawyer for the Dutch East India Company. That is not an aspect of Grotius which is sufficiently appreciated, I feel. But he was, in other words, he was, you could say, counsel to one of the major multinationals of his time, in short. And so Grotius also talked about this right to trade. By the time we come to the 19th century, we have situations such as the Chinese and the British, and the whole set of circumstances that led to the Opium Wars. So here, England says, we're growing our opium in India, and we have a right to sell this in China. And if the Chinese emperor resists us, then the Chinese emperor is in violation of various principles of international law. And as a result, we can go to war. And as a result of this war, a treaty is established, the Treaty of Nanjing. And under this, China pays reparations to the British for the damage they've done to the British opium trade. So we can see the way in which it is through the mechanism of trade that conquest takes place. And once conquest takes place, then the whole issue of migration is made very easy, because then you are not entering a foreign country, you are now entering your own country, which might happen to be Australia, but it's still England, if you know what I mean. And so it's in this way that we can't separate the idea of travel and migration from these other concepts, these other, you could say, realities in terms of historical and political circumstances. This whole area of international law is generally called the rights of aliens. And what is interesting about this is that a clear division was made between Western states, which could defend their borders and which were given the legal right to defend their borders. On the other hand, when it came to non-Western states, the basic argument made about these non-Western states was that they had to devise a system of government that could properly protect the rights of foreigners. So, if China or even, Turkey or Thailand, or Siam as it was known, if these states were unable to protect the rights of foreigners, then they were not proper states. So what we see there is a very interesting reversal, because what in effect was said in the 19th century was that if you don't protect the rights of foreigners appropriately, then you are not sovereign. And if you are not sovereign, then we will have to try and provide you with a system of government that would be appropriate. So what is very interesting here is that it is the rights of sovereignty, the rights of aliens that determine the sovereignty of the non-Western states. And I can, of course, the nice thing about the 19th century is that the scholars of the time didn't hold back. I mean, they weren't particularly politically correct about the way they talked about these issues. So one can always cite some, some fairly interesting passages. So this is John Westlake, professor of law in Cambridge, writing at the end of the 19th century. And he says, when the people of European race come into contact with American or African tribes, the prime necessity is a government under the protection of which the former, that is, the people of European race, may carry on the complex life to which they have become accustomed in their homes. And the question then is, can the natives furnish such a government? Or can it be looked for from Europeans alone? In the answer to that question lies for international law the difference between civilization and the want of it. And I would suggest that we can still see some ideas that continue this tradition when we talk about many of the modern initiatives of good governance. That has become a major preoccupation of development studies and so forth. And I think there is a lot to be said for good governance. But it has to be governance that meets the needs of the people rather than of the foreigners who are seeking entry into these countries. The other interesting thing about the rights of aliens, I've just got 3 minutes, is the fact that in terms of relations between equal sovereign states, the whole question of the rights of aliens, to a large extent, was developed, and this is going to the issue of paradigms, it was developed in terms of protecting the rights of foreign investors. Because when we talk about aliens, much of the law focused on the rights of corporations which were being nationalized by, for example, a huge number of cases emerged in relation to the nationalization by Mexico of United States foreign investments. And so I don't have time to go into this, but my broad claim is that the rights of aliens has developed far more extensively in terms of the protection of the rights of foreign investors than it has developed in relation to the issue of migrants. And so there are complex issues in terms of the North and the South, the rich and the poor. And even what Wayne said suggests that. There is open migration or endless migration that is available to, well, chief executives and, well, even perhaps professors. We shouldn't, delude ourselves about our privilege. But when it comes to migrant workers, the most disadvantaged, the most vulnerable, the protections are far less significant. I don't have time to go into the whole issue of international human rights law, but that is the one, you could say, promising area, because the fundamental claim of international human rights law is that everybody has rights, simply by virtue of being human. And whether these people are foreigners or legal or illegal or even suspected terrorists, they do have rights which have to be respected. So that is a basis on which hopefully some kind of a law can develop that will protect the other side of globalization, the disadvantage in globalization, in a situation where I would suggest that we are now at a stage where intellectual property rights are more protected by the World Trade Organization than the rights of migrant workers. I can't go into that whole set of issues, but what I'm basically arguing is that we have to see migrant workers in terms of the broader set of issues of globalization. And for that, we need to place migrant workers in the context of the law of foreign investment, the law of trade, the law of intellectual property. And I would say that when it comes to all those other areas of law, there is far more that has been developed than has been the case in terms of the rights of migrants. So I haven't stopped. Oh, I've got one more minute. Great. So the final thing I was going to say is the hope that we have for migrant workers, and this is something that is being taken up by development scholars, because the remittances of migrant workers play a huge and important role now in helping developing countries. And there are many, you could say, positive things about these remittances because they are sent directly to the people who need the money. It's not through some bureaucracy that this money is being sent. And so, we have families who rely on these remittances. And in recent times, the international community at least has got to the point where it has been able to draft and establish a convention called the International Convention on the Protection of the Rights of Migrant Workers, dealing explicitly with migrant workers. That is a very important convention. The only problem is that not many states have signed on and ratified it. And again, that contrasts with the World Trade Organization, the WTO, which is something that everybody wants to sign on to. And so again, we see those imbalances that I think we need to perhaps address in more detail later. Thanks very much.
And our final speaker concluding this panel is Professor Chatterjee. After that, we'll open for questions.
Time is short, so I'll try to be very brief. I would like to, in fact, pick up this last point that Tony mentioned about human rights, which is that everybody has rights by virtue of being human. Everybody has rights by virtue of being human, which is, in fact, one fundamental tenet of the concept of human rights. Now, the irony is this. Liberal democracies in the countries in Western Europe, and of course our United States in North America, they are based their foreign policy. In fact, their whole philosophy is based on the idea of human rights, both for their citizens and for anybody who is around anywhere. Now, the question then is how, based on this idea of commitment to human rights that we find in liberal democracies, can we justify a rather exclusionary immigration policy that bars the entry of economically desperate, poor, and the distant needy. So I would be raising some normative issues and normative questions, not necessarily the details of international law or rules of any sort, but certain broad normative ethical questions, which is, if we are committed to human rights, how can we, in a principled way, based on good normative ideals, make a distinction between our own, let's say our compatriots or compatriots, and the outsiders. Can this outside-inside distinction, when it comes to human rights, be maintained, based on which we find much of the immigration policies of the Western liberal democracies are based, and yet there is this problem and this paradox. Now that leads to something a bit more fundamental in normative theory, which is that liberal theories, as much as they have been committed to human rights, rights of all humans are equal. That is in fact a very fundamental principle of the liberal philosophy that Western liberal democracies hold on to. They in fact do have problem when it comes to thinking of their just society that tries to extend its principles of this cosmopolitan human rights ideas beyond borders. In fact, all liberal democracies happen to be based on the idea of a nation-centered polity. And to the extent it is that way, the question of exclusion and inclusion comes in. Could we morally have a justification? That is in fact a central paradox and a dilemma for the liberals. How could their egalitarianism be not global? How could they stop it at the national borders? What is the moral magic of national boundaries that could lead to this sort of an exclusion? Think about it. When it comes to egregious violation of negative human rights abroad, then there are some specific provision for special emergency refugee status of incoming immigrants if they are subject to ongoing egregious violation of negative rights. But if we believe truly in human rights, we have to go beyond the narrow definition of negative rights to talk more certain fundamental basic rights that includes and incorporates both negative and positive rights, and especially the positive rights of sustenance, a reasonably good and decent life for which economic and other opportunities and factors are extremely important. So the question is, why shouldn't the economically desperate poor from abroad be allowed on the basis of same principle as when people who are subject to egregious violation of the negative rights be allowed? How can we think of a new way of looking at human rights that would be more consistent with egalitarianism of the global egalitarianism of liberal democracy? Now, naturally there is this understanding that we do have sentiments of nationalism. This co-patriot partiality is rather deep-rooted in human nature. We think that our own has some special demand on us, and their needs count more, perhaps, than the need of the distant needy. I would like to really question that. Can we have any principled justification for that type of distinction between needs? Now, as I do this, I would like to especially put the so-called liberal nationalists to task, because they say that, as to the extent they're liberal, they do believe in global impartiality thesis, and at the same time they do believe in the national boundaries of a liberal polity, a liberal democratic polity, and they believe that compatriots' needs should have some priority over the needs of the distant folks, even though they might be desperate otherwise. Now, what is the basis of this liberal nationalism, which is one very widespread principled philosophy for this discrimination between the outsiders and insiders. Can a liberal principle uphold that? So what's liberal nationalism? Well, they try to say that our compatriots matter, their needs matter more, even though they're no more of a human being than others. We surely respect everybody, but their concerns, their needs are more important than ours. Why? Because the whole idea of democracy has something that goes with it, which is that in a democratic governance, citizens have a say in the governance. Why? Because after all, based on certain idea of social contract of some hypothetical sort or whatever, they have consented to it for some mutual governance, and that comes with certain shared expectations of obligations. So bonded citizenry have certain duties toward each other that those who don't belong to that governance system don't quite have it. Now, in today's globalized world, it seems like it's hard to make a case for something like that. Of course, surely the idea is not that every country has to take care of the distant needy in some foreign countries directly on a citizen-wise basis. No, because that will lead to all sorts of practical and moral questions and policy questions of humanitarian intervention and all other thorny issues. But if we do believe in the idea of democratic citizenship that comes with certain obligations, why can't we think of a democratic global order where there could be a democracy of democracies, or at least democracy or democratic equality between countries? And that surely could be something that could be espoused by the liberal democracies, those who value the idea of equality and the idea of democracy. But as we see today, there is a stark differential, treatment when it comes to the distant needy. Why? Because we do have free flow of capitals. That's always encouraged, that helps the rich and affluent countries, but we don't have a corresponding free flow of labor, which would have helped the poor countries. Now, studies after studies have shown that the state failure to respond to citizens' basic needs is more often due to the inequity in the global order itself than due to some problem in the governance of that specific country. So that means if we can somehow have an egalitarian democratic global order, which we don't have today, it's extremely slanted in favor of the rich and the powerful, then we can still maintain this idea of democratic equality, but instead of having that applied from the governments to all the citizens in the world, in their respective countries, we can do it between the nations. And so that has some implications. This type of indirect democratic obligation leads to liberalization of policies, so much so that we would then be responsible for the need of the distant needy, perhaps not directly. Often that's not possible because there are other overriding considerations that need not be moral, but perhaps contingent and factual or empirical, like the cost factor, like safety and those issues. But I would like to point out that in a globalized world, the cost factor has often been made into a red herring. The safety issue has often been also made into red herring. This idea of nationalistic sentiment, that often has been made into a red herring too. You know why? Because look at the contingency of sentiments. Sentiments could be reprogrammed. They could be reshaped. We have certain sentiments in a certain way because the way we have grown up, the way we have been programmed. So we do like to believe that we have more obligation towards our own because of, yes, I'll take just only 1 minute, because of the fact that we have natural partiality based on certain sentiment toward our own fellow beings, and that's very natural, very human. That's understandable. But that's also because of a contingent factor, not because of any principled moral reason, but on a contingent factor, which is that it's based on a contingent factor, which is that that's how we have grown up in a polity of solid borders. But if we can have a global consciousness based on certain inculcation of global citizenship, so naturally you will find more of the global awareness will supplement our national sentimentalism that favors co-patriots. Okay, so given this, I would like to really find out, yes, what could be a principled moral reason for excluding the distant needy. I do not find one. I would like to show when it comes to liberal nationalism, whether based on the idea that, well, if people are coerced based on certain mutual agreements, then naturally they get special preference from their own governments, which they don't, which other folks in other countries don't have it because they don't haven't entered that type of agreement with the government of our countries. That doesn't quite really hold, because I would like to see that we have a democracy of democracies, or democracy of democratic order amongst countries than amongst countries and citizens all over the world. Anyway, so based on that, am I advocating a totally open border? Perhaps not necessarily. I'm talking about perhaps more of a porous border. And we'll be hearing a lot more about these things in our plenary talk today by Professor Sela Ben-Habib, who has championed some of these ideas. But the idea is that the policies could be a lot more liberalized than we have done, than they have been so far, because there is no principled moral justification. If it's a matter of practical, contingent cost factors and other things, those things are changeable. Anyway, so I didn't get into any of the technicalities of my presentation. That's in the essay. Just wanted to give you just the summation of it. Thank you.
This is a great panel, and I want to open it up for questions now, but I wanted to just make a couple of observations about how complementary many of the themes that sounded in these papers are. We began with Professors Stewart and Jameson, who really took us through deconstructing what the narrative about inclusion and exclusion has been in our own home state of Utah. We've seen our policymakers learning socially through finding an accumulation of anomalies against this backdrop that hadn't previously been articulated about how we think about who we include, who we exclude, and why. And what emerged was a very pragmatic solution to a problem without a larger sounding context around it. Professor McCormack gave us some of that context and how courts have thought about it at the the national level. The Supreme Court opinion, I think you were talking about Plyler versus Doe. Again, very pragmatic an approach to a problem of people we have included within our borders, yet we've excluded. Professor Anghie has given us some insight into how it is this conversation is so derailed and deranged, because it really came, at least in the international area, not out of the concern for individuals or migrants in particular, but out of investment, exchange, and an open right to travel and trade. Looks very on its head when taken outside of the 19th century. What would it be to define the sovereignty of the United States around how our migrants experience their lives here? And then ultimately, Professor Chatterjee has helped us think through the inconsistencies of a broad view of liberalism that is narrowed and confined to particular borders. If it is the case that liberalism demands that we respect autonomy and choice, but also structures that around borders and not a more global vision, does it present us with some tensions? The other course I teach at the law school is constitutional law, and in my course I teach Dred Scott versus Sanford. And in that case, it was a not free slave, an escaped slave who crossed from the southern territories into the north and demanded his freedom in court. Ultimately, his case was dismissed because he's not a citizen. He doesn't have the right to bring this suit. So here is a paradigmatic example of the meaning that inclusion can brought for people in very real ways about their human dignity. And with those observations, I'll simply turn it over to you for further questions to unpack some of the tensions here. Yeah.
Good morning. I'm Patricia Fernandez-Kelly from Princeton University, and I agree with Professor George. It's a wonderful panel, very informative. I just want to ask a very, very simple question. I found your presentation, Professor Mercer County. And we have confronted some of these debates about a license that affords drivers privileges. Pretty much after the watered-down version in New York. But one of our concerns has been that this becomes a scarlet letter right on the foreheads of people without proper documentation. And I gathered from your remarks that this has not presented a big problem in Utah. So I'd love your commentary because we could learn from that if in fact it works. So could you enlighten us?
No, that was one of the fears, as one of the people who was getting the driver's privilege card said, "You know who I am now. You can pick me up." But that has not, to my knowledge, we've had problems with immigration raids, but to my knowledge, that has not been a factor in it. It has been through the employment side on that. And I think that is a continual tension as the anti-immigrant forces want to utilize domestic police forces or local police forces in enforcing immigration laws. But thus far, we had a police chief in town who wanted to do that, who has moved on. Thus far, I think cooler heads have prevailed and said it's much more important to allow people to come out and have protections rather than to force them into the shadows, as we said. So.
It's apparently much more enlightened people in Utah.
Oh my goodness. Thank you very much.
I have a question for Professor Anghie and Professor Chatterjee. All these human rights goes back to the 1951 Declaration of Human Rights. So either one of you request or recommend change or revision of those rights?
Change or revision of the existing human rights regime?
Well, I suppose my quick comment would be that, in fact, human rights has continuously evolved since 1950. And so now we have the Universal Declaration on Human Rights in 1948 or whatever it is. But since then, we've had covenants on civil and political rights, economic and social rights, covenants dealing specifically with the rights of women, and now comments dealing with the rights of migrant workers. So I would say that, in fact, human rights has continuously evolved to try and capture these more complex realities that have emerged. The other thing I might just say, just to follow up on something that Deen mentioned, I think the complication about human rights is that human rights plays in completely, I think, to the type of liberal nationalism that you would be opposed to, because human rights says we only have human rights obligations towards people in our territory. So in other words, human rights itself is very state-oriented. Whereas I think what is needed, for example, with economic and social rights, is an argument that we have obligations to people everywhere, not just to people within our territory and also within our jurisdiction. This is why Guantanamo is so complicated, because it's the question of jurisdiction or not. So human rights itself is still very much state-oriented, even though human rights is supposed to be a check against the state. But it reinforces the state in a certain way.
Just one quick comment. The idea of human rights, since the big declaration in the early 50s, has gone through several phases. The first phase of political and social rights, the second phase later in the early 60s of economic and welfare rights, and now, of course, we see the third phase of other issues, animal rights, environmental rights, and all that. Anyway, so the thing is that my basic puzzle that I am grappling with in my presentation is how can we hold on to a certain robust notion of human rights in all its variations and manifestations and still be exclusionary in a very obvious sense. My point was that how could human rights theorists not be cosmopolitans in some sense of the term? Now, cosmopolitan is a tricky issue. And Professor Ben-Habib has been doing a lot of work in that area to show in what way we can balance, the demands, specific demands of our compatriots or the local culture and the global demands of a cosmopolitan mindset. But the point is that there has to be some version of cosmopolitanism ingrained in the concept of human rights. And if it's that obvious exclusion of the outsiders and insiders, and if that be an ingredient of the idea of human rights, then somehow it's self-defeating. And yet, in a way, that liberal nationalists, along the line that Shoni pointed out, they try to play with that to show that they can be global egalitarians and at the same time they can defend compatriot partiality. I think they can't have it both ways.
Yeah. As you're saying that, I mean, some of this is, and I'll take the next question, I know Wayne wanted to respond, just procedurally, structurally, human rights is state-oriented because states are signatories to the conventions that are creating the rights. And as a procedural matter, they then define, okay, I am taking on these obligations as a state party for those within my borders or jurisdiction. And often citizenship is a key part of that. So until it is maybe imbued or informed philosophically with the more cosmopolitan reasoning behind the universalism that it purports to have, this will remain a problem. Very important question.
I have to intervene. I think it's much more complicated than that. One of the human rights that we have recognized is the idea of self-determination. We have this notion of cultural, economic, social identity, which feeds into, unfortunately, ethno-cultural conflict. But it also feeds the idea of preservation of diversity. If we really are so cosmopolitan that we break down all cultural identity, is that a safe and a desirable condition for the world? I'm not sure that we really want that degree of philosophical equality of identity. So I think it's much more complex than just saying that the nation exists because the nation exists. Nations exist in part for this idea of preserving some kind of identity and diversity.
Okay. Question here, and also a question? I'm going to take both questions and then open it back to the panel.
My question, from BYU, is to Anghie. If you say human rights is state contextualized, then what is the essence of establishment of all these international agencies such as the World Bank, the IMF, and WTO?
Yeah. Okay.
I'm Dick Billsborough. I'll be talking later about things that I know something about. This is something I don't know much about, except I've been involved in a lot of United Nations meetings discussing international migration. And my friends at the UN who collect the data and produce the data on measures of migration tell me that this issue of citizenship and of sovereignty is a fundamental issue that comes up all the time in their debates. And a question that I think you were implying is, what is the meaning of citizenship? What is the meaning of national borders if not giving countries the obligation to protect the people who are citizens, and therefore not necessarily having any obligations to non-citizens, and also the right to protect people within their borders and to consider the borders as impermeable if they choose to do so. Now this conflicts, and this issue of national sovereignty is brought up a lot by countries debating at the UN, and there's been a lot of tension between countries receiving immigrants, the U.S. being the prominent one in recent years, not wanting to even have an international debate on the rights of migrants, to free movement, for example, versus developing country governments which want their citizens to be able to freely move. So this issue of the tension between governments and their concept of sovereignty and protecting citizens versus most of the UN executive people that are working there are very liberal and have a cosmopolitan idea. So they're interested in the rights of migrants, migrant workers, and universal rights. And they're concerned about the fact that most of these UN conventions are not signed by most countries in the world, including the United States. And it's rather appalling to see how many of these conventions the U.S. has not signed. Thank you.
Yeah, on that note, and Professor Anghie started to mention the 2003, well, it entered into force, the Migrants' Rights Convention in 2003, and not surprisingly, receiving countries are not signatories, and sending countries are signatories. And this remains a persistent problem for activists who are trying to get more countries to ratify that document. It is a very rich and protective document for the rights of migrants, but there's far from agreement on how those rights would look, and certainly in the states that are affected by it to receive people. So we've got two questions, one to Professor Anghie, I guess another to the panel as a whole on these issues.
Yes, the professor's question, as I understood it, was that human rights are, my claim was that human rights are state-oriented, and I think your argument was that organizations like the World Bank and the WTO seem to be globally oriented. I'm sorry, I'm just trying to sort of get a clearer sense. Well, certainly I would say all international institutions, including international human rights institutions, would claim to be concerned about the well-being of citizens everywhere. I would say that the World Bank and the IMF and so on are organizations which, going back to what I mentioned earlier, organizations which deal more with, which are explicitly deal, the World Bank deals with, with development aid, the IMF with finance and so on. And so one of the claims I'm making is that, and Deen mentions this as well, that migration is controlled, whereas capital and trade is really internationalized. And that's what gives the WTO massive jurisdiction, because all 120 countries have signed on to the WTO. And what is interesting about the WTO is that it is indirectly impinging on human rights, I would argue, because there is a relationship between trade and human rights, especially when it comes to economic and social rights. But it seems to me that these are sort of global organizations dealing with a global set of interests, whereas human rights, I would still claim, is state-oriented, including in the way in which human rights are enforced. So, for instance, we tend to think of human rights as being, once a country signs on to a human rights treaty, then individuals can make a claim against that country citing the treaty. That is not the case. The main mechanism for enforcing human rights is if another state criticizes the state which has committed the offense. Does that make sense? So if England and the United States have signed the same human rights treaty, and England violates that treaty, it is not the individual generally who can bring the claim on the basis of human rights. It is the United States criticizing England for violating the treaty. In other words, the person who is supposed to benefit from the rights, that is the individual, does not have standing in the international system to bring a claim against the state for that. I would say that is true of most treaties. There are exceptions, of course, with the European, certainly. That's the major exception, which is the most liberal system.
The European Convention for Fundamental Freedoms and Human Rights, which doesn't just cover EU countries. Countries like Russia and Turkey are also members. And as a Turkish Kurd, you can go directly to the European Court of Human Rights and make a plea for discrimination, torture, etc. I mean, I'm sorry to have interjected.
No, you're quite right.
It's in general what you're saying, Tony, is true, but look, there's something about the logic of human rights. What are human rights? It's not like my having black hair or green eyes. Human rights are about a system of life and a system of interaction, and it involves a community of sorts, an interactional community. So in some sense, you do need a political structure within which rights are realized. If you're not going to think of rights simply as individual, properties, but it seems to me as if the very language of human rights right now also creates possibilities for societal groups. I mean, the European Convention has mechanisms for an individual to keep human rights, but there are many, many organizations in the world who use, for example, let's say the Convention Against Discrimination for again, women. You have many groups who are bringing charges against their own or claims against their own government to transform or reform rape laws.
Sure.
They may or may not have standing, but
That's
they're
right.
mobilizing society.
Yeah. Yeah.
So,
No,
we appreciate the interjection, but I also am afraid I have to bring the panel to conclusion. So I hope the other question can be addressed in our break. We're breaking for a short break, and I wanted to remind you that our next panel with our two guest scholars, one of our questioners, Richard Bilbaro, and Patricia Fernandez-Kelly, will begin after our break. Thank you for your participation, and join me in thanking the panel for an engaging session.